Hey guys, I'm Kate Bihm. I'm a family lawyer in Montgomery County, Texas. And today I wanted to talk to you about the 3 most common objections that I hear in family court. Now, I'm a Texas lawyer, so here today I'm talking about the Texas rules of evidence. If you live in another state or your case is pending in another state, the rules of evidence are different in that state, so you need to talk to your lawyer. Also, keep in mind, this information is just for the public to have a better understanding of lawyers and how we operate. It's not legal advice. So if you have a current case pending and you think you're going to wind up in court, you need to talk to your lawyer about what's likely to happen there and what their expectations are of you. That being said, let's get into it. So the Texas rules of evidence are designed to be exclusionary. They're not designed to let every single thing in. They're actually designed to keep evidence out that may not be reliable for the court to consider. And so objections are a way that lawyers that are in court notify the judge that somebody may be violating a rule of evidence. The 3 most common objections that I see are the following: speculation, hearsay, and non-responsive. Let's start first with speculation. So I've been with my husband for 15 years. I promise you that if he says something or does something, I can probably tell you exactly what he's thinking when he does it and why it is that he's doing it. But in Texas, the rules of evidence say that you're not actually allowed to do that. You're not allowed to speculate about why somebody is doing what they're doing or what their motives are. Now, if somebody comes to you and says, for example, I shot him because I was mad at him because he said something bad to me, then you can certainly go into court and say, that person told me that they shot somebody because that person did X, Y, and Z, and that's okay. But if you are speculating, like, well, I think that the reason why they turned right at the traffic light was because they were heading this place, that's speculating. Unless they told you why they were doing what they were doing, you're not allowed to speculate. And so the proper objection there is to say, objection, speculation. And people are often really frustrated by that objection, especially in divorce cases or child custody cases, because people know their kids, they know their spouse, they know why they're doing what they're doing. But the rules of evidence say that you're not allowed to guess and you're not allowed to rely upon your past experience with them to presume that they're acting in a certain way just because that's the reasons why they've acted that way in the past. Next, hearsay. Hearsay is probably the single most common objection in any field of law in the state of Texas. It's got to be. All right, so what is hearsay? Hearsay is when we're relying upon something that a person said outside of the courtroom, and we're offering what they said into evidence to prove that what they said is true. So, where hearsay gets really difficult is that there are tons of exceptions and exclusions from the hearsay rule. And that can be very confusing because there are times when what somebody said outside of court is 100% admissible, provided you can prove that it meets one of those exceptions or those exclusions. But again, where this often gets really frustrating in family court is people want to go into court and they want to say, my kid told me they saw their dad smoking meth, or my child told me that their dad had 8 beers at the bar and then drove them home. But unless it falls within one of those exceptions or exclusions, you're not allowed to come into court and say what your children told you. One of the main exceptions to the hearsay rule or exclusions to the hearsay rule is what we call a statement by a party opponent. And so in a divorce case, for example, the husband can come into court and basically say anything in the world that his wife has ever said to him. And that is going to fall into an exception or exclusion to the hearsay rule. And so that is something that people often rely upon. In cases involving adultery, they're like, well, I don't have any proof that my spouse cheated on me. And I always ask them, I'm like, well, did you confront him about it? And they're like, well, yes. What did they say? well, yeah, he admitted that he cheated. And I was like, well, that's good. That's evidence. We can bring that into court and we can talk about that. Now, if his side piece came in and told you, hey, I've been sleeping with your husband, that's hearsay, and you may not be able to have that admitted unless it falls within a specific exception or exclusion. So whether you're going to be able to get hearsay evidence into court is, one, an important part of trial preparation with your attorney, and two, it's going to require that your attorney have a really clear understanding of the exceptions or exclusions to hearsay under the Texas Rules of Evidence, because there are often ways that you can get it in if you can fit it within one of those exceptions or exclusions. But generally speaking, you are not allowed to come into court and say what anybody else has said to you outside the courtroom, except for the party on the other side of the lawsuit. And that can get really complicated, especially in family law cases. But if you have an experienced trial attorney for your lawyer, hopefully they can figure out a way to get it in through one of the exceptions or exclusions. Last is non-responsive. This is a really difficult objection to overcome because it requires that you as a witness be really well trained as a witness. And so what you need to understand about being responsive to questions is that in the courtroom, you're really only allowed to answer the question that's asked. So if someone asks you, do you know what time it is? And you look at your watch and you say, yeah, it's 1:10. Well, your answer was actually non-responsive to the question because they didn't ask you, what is the time? Or please tell me the time. They asked you, do you know what time it is? The answer to that's yes or no. Confusing, right? So one of the really important things about being on the witness stand is you have to, in a really short period of time, listen to the question that was asked, process exactly the question that was asked, and only answer that question. So just to clarify, if someone says to you, do you know the time? Anything after yes is non-responsive to the question. It can be really tempting to listen to the question and say, yeah, but I want to provide an explanation. And you're not always allowed to do that. So if your inclination is to say, yes, but, or no, and, you need to remember that if you've been asked a yes or no question, the but and what follows, or the and what follows, is non-responsive to the question. However, under Texas law, your attorney can always ask you questions again, and so you may have an opportunity for them to clear up and get an explanation at that time. But it's important to remember that if you answer a question that's different than the one that's asked, or if you add information that wasn't asked for, you may draw an objection for non-responsiveness. And I can promise you this, after 20 years in the courtroom, if you keep being non-responsive to the questions that are being asked, the judge is going to start to have concerns about your credibility because they may believe that you're there to tell your story no matter what the other lawyer is asking you, and that can be a really dangerous place to be. So talk to your lawyer before you get on the witness stand about some of these objections and about what they want you to do while you're on the witness stand so that you have a clear understanding of what your judge's expectations are when you're a witness, because that's an important part of your credibility when you're before the court. And if there's one thing you don't want to do when you're in a courtroom and your kids are on the line or your divorce is on the line, is for the judge to, one, think you're not credible, and two, for the court to have some concerns about why you're there and what it is that you're there to do, right? Like that's such an important part of it. And you want the judge to like you. Sometimes being in court is a little bit of a personality contest. It's a little bit of a popularity contest. And careful preparation can help you prepare for your judge's expectations so that you can meet your judge's expectations and hopefully have a great outcome. Good luck in court.